You're about to hear from Andrew Walker. Andrew came to the bar in 2009. Prior to that, he'd practiced as a solicitor for over 10 years, most recently as special counsel with DLA Phillips Fox Planning Environment and Local Government team, and before that he'd been at Hunt & Hunt as a senior associate in the City of Melbourne as in-house counsel, and also enjoyed some interest, some part of his career in a very much a coastal area at Tate Solicitors down in Warrnambool. Andrew specialises in planning, environment and local government law and has appeared for and advised developers, councils, statutory authorities and objectors in a range of VCAT, planning panels, Victoria, Supreme Court, Federal Court and Magistrates Court matters. Andrew also has extensive experience in advising councils, developers, landowners and statutory authorities in compulsory acquisition, valuation and property-related matters. He's also active in the planning law community. Andrew lectures in planning law at the University of Melbourne and is a Law Institute of Victoria accredited planning and environment law specialist. He sits on the committee setting specialist planning and environment law exams and on the editorial board of the Australian Environmental Review. So it's a very broad depth of experience.
Thanks, John. Being last, of course, I have the joy of having to be flexible and often put in the position of having to filibuster or be fast. It's the latter that applies in this case. As you've heard from the other speakers, the main issue here is you can have a block of land which may on its face seem developable for a dwelling. For example, it's zoned residential 1 zone, but it can't be developed. Further, as Tiphanie said, and Tom has also said, you can't necessarily pick up that fact from looking at the planning certificate or the Section 32 statement. Finally, a solicitor acting for a purchaser may be negligent, depending on the circumstances, if they fail to advise a purchaser of that fact. Now, I'm going to talk about 5 examples of such a situation where on its face land may be developable, but in fact due to planning controls you can't develop it. And they are development in water catchments, dwellings on small rural allotments, dwellings next to offensive industries, demolishing buildings in a heritage overlay situation and restructure overlays. Now, Tom's gone through the various planning controls. I've really summarised their effect in that slide there. So, in a nutshell, the zoning controls may permit a certain use or development. So, residential 1 zone, for example, you can have a dwelling without needing a permit. Rural zone, you can have a dwelling, but you need to get a permit. Further, overlay controls may also impose a trigger for the need to get a permit. So heritage overlay, need a permit to demolish a dwelling. But just because you can get a permit doesn't mean you will get a permit. And if you can't get a permit, the property may, as a result, be virtually worthless. So again, given land values and purchase prices and the like, it's a hot area in terms of potential liability for property lawyers. Now, Tiffany's talked about the bushfire management overlay and fire risks and development in coastal areas. The rationale for VCAT's approach in these cases is really as a result of the Rosen saga. And in Rosen, the Supreme Court determined that in the case of water catchments and developments in water catchments, the tribunal had to apply what's called the Precautionary Principle. Now, I won't attempt to explain the Precautionary Principle in the time I have available, but in a nutshell, it's summarised in the bottom line there in the decision of Leach. So, decision makers should be cautious And that's really the approach the tribunal has adopted when it comes to fire risk, development along coastlines, and also development in potable water supply catchment areas. Now, I've set out the various Rosen decisions. The poor Rosens, they applied for a permit. They went to VCAT. The Water Authority appealed to the Supreme Court. So it went to the Supreme Court, successful appeal, back to VCAT, and they lost. So, yeah, an unfortunate situation. But really, the basis of the appeal was that the tribunal had failed to properly take into account the precautionary principle, as set out in the previous slide, and also failed to properly apply guidelines which recommended that in a water catchment there be a dwelling density of 1 lot per 40 hectares. So how has the tribunal approached development in potable water catchments since Rosen? Well, not surprisingly, with caution. So there are a couple of decisions I've set out in the slide there, and there are a string of other cases where basically the tribunal has applied this 1 in 40 rule. So if you're in a water catchment and you're seeking to obtain a density of more than 1 lot per 40 hectares, the tribunal said, no, too risky. Now, that's something that you wouldn't pick up necessarily from the planning certificate or a search of the Section 32 statement. So, for example, dealing with the Selman case, I don't know how many of you know the little hamlet of Riddles Creek just north of Melbourne, but this was land that was zoned township zone. So within the township and on its face land which you would think could be, in this case, subdivided into 2 lots with a new dwelling constructed on the second lot. The tribunal said no, on the basis that the density of dwellings was greater than 1 in 40 and there was no reticulated sewerage and water supply, so the risk of using a wastewater treatment system, or to use the old term septic tank, was too great. Again, in Capyrus, the other decision in the slide, the land was an undeveloped 16 hectare lot in a rural conservation zone. So again, a fairly large lot. The tribunal again applied the 1 lot per 40 hectare guideline and found that the dwelling density had been exceeded, and on that basis refused to grant a permit for a dwelling. So again, land virtually worthless, can't be used, or a dwelling can't be constructed on the land. And I might say that was despite the fact that the tribunal concluded that with the high quality wastewater system proposed to be used, there was in fact little risk to human health as a result of the proposal. All right, now in the vein of doing this very quickly, I'll move on to dwellings on small rural allotments. And again, this is a situation where the planning scheme indicates that you can obtain a planning permit to put a lot on a small rural lot. But you need to delve deeper than that, because a number of rural councils have, Tom took you through the structure of the planning scheme, a number of rural councils in their suite of local planning policies have policies discouraging or strongly discouraging dwellings on small rural allotments. When it comes to state planning policy, also there is a strong discouragement for the fragmentation of productive agricultural land. So again, there are a string of cases where the tribunal has refused to grant permission for a dwelling to be constructed on a small rural allotment, or subdivision to occur, subdividing off an existing dwelling and creating a balanced lot. So again, if that's what a purchaser has in mind, it is relevant if they ask the question to advise them that it's unlikely they would be successful in such an application or proposal. Moving quickly to the next grab bag of issues. Dwellings next to offensive industries, and this is the reverse amenity principle. Again, this is just one example of many. This involved a situation where there was land in a green wedge zone, an application on a dwelling for a 2.05 hectare lot, so your classic tree change lot on the Mornington Peninsula. However, there was a broiler farm in reasonably close proximity to the land, and the tribunal determined that given odours associated with the use of the broiler farm, you could say foul odours, I suppose, if you were. It was inappropriate to construct a dwelling in this location. I thought I'd wake them up a bit, John. So, again, there are a number of dwellings in the area. If you looked at the area, you'd think, well, it's a small lot, it's appropriate to put a dwelling on there. Really, there's no other use for a 2.05 hectare lot. But tribunal said no, and you wouldn't necessarily ascertain that the tribunal would say no on just looking at the Section 32 statement and planning certificate. Now, again, fragmentation of productive rural land was also an issue in this case. So Mr. Brown bought his tree change lot, planning to build his dream house, but he didn't count his chickens before they were hatched. That's it for the bad jokes, by the way. Demolishing buildings subject to a heritage overlay. The difficulty here is that Minister Guy, the Planning Minister, has been fairly trigger happy when it comes to making ministerial amendments. Basically, the Minister has the power to amend the scheme without giving notice to anyone. As I found out after 5 days of a 10-day case where on day 6 the Minister changed the scheme to basically prohibit the development proposed. So the whole hearing had to be adjourned and 5 days of hearing were wasted due to a ministerial fast-track amendment process. But anyway, I digress. A landowner is not protected from the impact of a heritage overlay, even if the landowner has a building permit for demolition. And there are 2 cases which stand for that proposition. One was an unfortunate situation I was involved in Meraki, where the landowner had a demolition permit, had started demolishing, got a letter from the council saying the minister's issued a fast-track planning scheme amendment for your land. You now can't demolish the building. Yes, it was argued, well, we have a building in VCAT, we have a building permit, therefore we don't need to get a planning permit under the planning system. The tribunal didn't accept that argument. So it's important, and Tom took you through the planning certificate, which indicates that planning scheme amendments are shown on the certificate. It's very important to note if there's a proposal to introduce a heritage overlay. Further, there's a little trick in that I've talked about the fast-track amendment process. The usual process for amending a planning scheme is that there's advertising, submissions and the like. If there's a proposal under the usual amendment process to amend the planning scheme by putting in a heritage overlay, the council has the power to stymie an application for a building permit to demolish. So they can basically say, no, you can't get your building permit until such time as the planning scheme amendment has run its course. So again, that's a trap for purchasers, and you shouldn't assume because you've got a Building Act permit to demolish that you will in fact be able to demolish the building. Of course, heritage constraints are significant. As a general rule of thumb, it is hard to demolish a heritage building. Now, that does depend on the significance of the building. In fact, next week I'm involved in a 2-week case where the landowner has ascertained that the cost of just making the building structurally sound is going to amount to $2.5 million. And the council's saying, well, we don't care, we still want you to retain the building, you can't demolish it. So heritage overlay and the constraints of heritage overlay controls are significant. That's about it from me. I see I've pretty much kept to my time. Other overlay, unlike others, other overlay controls can severely restrict the development potential of land. We've talked about the heritage overlay. The other example is a design and development overlay, as Tom has mentioned. They can impose height controls, including mandatory height limits, and a bit of a quirky example there, probably not that common, is a restructure overlay, another example of a control where your ability to develop land for the purpose of one dwelling may be constrained.
Thank you to all, and in particular thank you to people for coming, and we'll now get on with the rest of our day's work. Thank you very much.